Qualified immunity matters because it often makes the practical difference between a ruined life and a real remedy for constitutional wrongs. Under the Civil Rights Act of 1871, codified at 42 U.S.C. 1983, citizens can sue state actors who violate constitutional rights, and that statute is the enforcement tool around which modern accountability turns. The doctrine of qualified immunity sits above that statute like a brass canopy meant to balance two public interests: protecting officials from harassing suits over good faith mistakes, while ensuring injured civilians can obtain redress when rights are clearly violated. That balancing act has a pedigree. In the mid-20th century, courts reframed older common law immunities to fit a growing administrative state and modern policing. Judges converted categorical immunities into calibrated protections, hoping to preserve vigorous public service without inviting litigation that would stifle decisive action. The result was a velvet-lined shield, procedural rules and tests that can dismiss suits before discovery, sparing officers and municipalities months or years of burdensome process. Yet that very mechanism, created for good government reasons, now fuels the central tension. Critics say the shield too often turns into impenetrable armor that blocks accountability and leaves constitutional injuries unredressed. Supporters counter that without robust protection, officials face crippling hindsight liability and defensive policing. The story ahead is not simple. A framework born to protect public servants and public order has become a contested legal fortress, setting up clashes over doctrine, evidence, municipal liability, and reform proposals that will drive Act 1. Upcoming chapters will force hard choices between citizen remedy and official protection. The modern arc of qualified immunity starts with Pearson v. Ray, where the court created a good faith refuge for officers sued under Section 1983, applying a subjective standard for arrests made pursuant to existing law. That approach shifted in Harlow v. Fitzgerald, which removed the subjective inquiry and adopted an objective reasonableness standard to spare officials the chilling burden of litigation by asking whether a reasonable officer could have believed the conduct lawful. Anderson v. Creighton then sharpened the test by requiring the unlawfulness to be clearly established, so reasonable officers would know they crossed a constitutional line. That phrase became the lodestar of future decisions. Saucier v. Katz introduced a two-step sequence. First, decide whether the facts show a constitutional violation, then decide whether the right was clearly established. The goal was to vindicate rights while clarifying future conduct. Pearson v. Callahan later gave courts discretion to skip the first step, letting judges dispose of cases on the clearly established prong alone, and often avoiding the task of clarifying legal rules for the future. That procedural discretion, combined with Anderson's demand for specificity, turned the clearly established test into a high barrier. Courts began requiring near-identical precedent rather than broader constitutional principles. A string of cases illustrates this pattern. In Brosseau v. Haugen, Mullenix v. Luna, and Casella v. Hughes, officers who used deadly force avoided liability because prior precedents did not present a factually identical set of circumstances, even where many commentators saw obvious constitutional problems. White v. Pauley underscored the point. The court faulted plaintiffs for failing to cite a close factual analog and awarded immunity. By contrast, Hope v. Pelzer, an Eighth Amendment case, and a few other decisions show plaintiffs prevailing where statutory or constitutional commands were sweeping and unmistakable. The net effect is predictable. Plaintiffs win when precedent is crisp and analogous. Defendants prevail when cases hinge on nuance and judges opt for Pearson-style pruning. That jurisprudential pattern sets the stage for the municipal liability debates and reform conversations that follow, where doctrine, accountability, and public concern collide. The legal balance shifts from individual shields to municipal armor under Monell v. Department of Social Services, 1978. The Supreme Court held that cities can be liable under Section 1983 only when a formal policy, an entrenched custom, or a policymaker's direct decision causes a constitutional violation. That doctrine raises the bar. Plaintiffs must do more than show an officer acted wrongly. They must connect the injury to a municipal command or a recurring practice. There are three familiar routes to municipal liability. One is an express written policy. A second is an informal custom so persistent and widespread that it functions as de facto policy. The third is a failure to train theory, where deliberate indifference to training makes predictable violations inevitable. A narrower, less common path is single incident liability, when a final policymaker's deliberate choice itself produces the deprivation. Courts, however, treat that option as narrow and highly fact-specific. In practice, these doctrines create evidentiary fortresses. Pattern and practice claims typically need proof of prior similar incidents, statistics, or personnel and internal affairs records that municipalities often resist releasing. Failure to train suits normally require expert testimony tying deficient training to foreseeable constitutional harms and evidence that policymakers knew the risk but consciously ignored it. Single decision theories demand clear proof that the official truly had final policymaking authority and intended the result, not simply supervised the officer. Qualified immunity can further shut down cases early. Dismissals on the clearly established prong often block discovery that would uncover municipal patterns. That interaction reshapes litigation strategy. Plaintiffs hone complaints to plead narrow, particularized facts that survive Rule 12 and trigger discovery. They use FOIA requests, whistleblower affidavits, civilian video, and social science experts to assemble a mosaic of custom. They choose between damage suits, which face higher pleading burdens, and injunctive or declaratory relief, which can force systemic fixes with lower barriers. Defenses lean on municipal budget constraints, claims of no prior incidents, and disputes over final policymaker status. Increasingly, advocates pair courtroom tactics with legislative and administrative campaigns, pushing for stronger records laws, consent decrees, civilian review boards, and state-level tort reforms to work around doctrinal limits. Those tactical calculations set the stage for Act 3, where reform proposals and comparative oversight models collide with entrenched legal realities. The fight over municipal armor has moved from courtroom skirmishes into the legislative and institutional arena, with sharp proposals that either aim to puncture or protect that velvet-lined shield. Some lawmakers are pushing for federal repeal or statutory limits on qualified immunity. Others are crafting state law pathways that preserve officers' access to defenses while still guaranteeing a private remedy under state constitutions or tort law. Several jurisdictions have adopted narrower fixes, limiting indemnification, shortening statutes of limitation for civil rights claims, or creating new causes of action that avoid federal hurdles. Parallel reforms target the accountability pipeline. Independent prosecutors and specially appointed counsel for police-involved deaths remove cases from local offices seen as conflicted. Statewide or regional prosecutorial units create a clearer separation between police and the officials who decide whether to charge. Decertification systems and stronger post boards offer administrative exit ramps, permanent revocation of badges for egregious misconduct, transparent decertification databases, and faster administrative hearings that do not rely on a criminal conviction. Transparency changes range from mandatory body-worn camera retention rules and open disciplinary records to early warning systems and compelled disclosure of use of force policies. Each is designed to build the evidentiary mosaic plaintiffs need to connect municipal patterns to constitutional harm. Civilian oversight experiments show sharp contrasts. Some cities give review boards subpoena power and binding disciplinary authority, effectively turning civilians into decision makers. Other cities give only advisory powers, creating softer oversight that unions and councils often prefer, but that rarely changes careers. Comparative democracies offer useful blueprints. The United Kingdom Independent Office for Police Conduct and many Canadian Special Investigations units combine statutory independence, dedicated investigators, and direct referral routes to prosecutors. Several Nordic countries embed civilian participation and prosecutorial independence in processes that emphasize swift, transparent inquiry. Leading city experiments illustrate the trade-offs. Full-blown police commissions like those proposed in Los Angeles or reformist consent decrees can deliver deep change but trigger bitter political fights. Modest transparency wins are easier to pass but less transformative. Camden-style reinventions of public safety show how far reform can go, but also how much political consensus and sustained investment they require. Resistance is relentless. Powerful police unions, skeptical judges wary of doctrinal change, and fiscal constraints that starve oversight efforts. The result is a clash between pragmatic design choices and entrenched institutional power, moving toward the inevitable moment when law, policy, and politics must decide whether the brass canopy will be reshaped or remain impenetrable. A headline-grabbing killing in a mid-sized city became a brass-bound crucible exposing the doctrines meant to regulate police power. A bystander filmed an officer's chokehold, and the footage, under sepia streetlights and the harsh glow of a police cruiser, went viral. Outrage followed. Mass marches, calls for accountability, and a family lawsuit under Section 1983 and Monell, federal civil rights and municipal liability claims. They sought damages and discovery into training files, internal complaints, and dispatch logs, and the local paper ran the officer's long disciplinary history. But at summary judgment, the judge found the officer entitled to qualified immunity because no prior case presented a nearly identical set of facts, and the Monell claim was dismissed for lack of an established pattern or a final policymaker decision. Discovery never unfolded. Subpoenas were blunt tools against a velvet-lined procedural fortress. The family watched civil liberty give way to legal formality. Months of therapy, lost wages, community distrust, and a small funeral where speakers described a life cut short while institutions remained unchanged. Policymakers issued sympathetic statements and offered token reforms, new training modules, a review board without subpoena power, measures meant to soothe but not to change the underlying incentives. The tableau forced a civic reckoning. The doctrines that shield officials, the evidentiary mountains plaintiffs must scale, and the political costs that blunt systemic change were no longer abstract criticisms, but tangible barriers to justice. That collision crystallized the question at the heart of reform debates. Are brass polishings enough, or is wholesale remodeling required? The dispute exploded into the wider public conversation and into impact. From that brass-bound crucible comes a clear tally of long-term stakes. Weaker civil rights enforcement if the velvet-lined doctrine survives, police behavior shaped by legal insulation rather than constitutional guardrails, and eroding public trust that corrodes the implicit contract between citizens and the state. The choice is blunt and binary. Preserve broad official discretion to protect split-second judgment, or insist on meaningful accountability that deters abuse and restores confidence. Realistic paths forward are pragmatic, not utopian. Targeted legislation can recalibrate or replace qualified immunity while preserving reasonable defenses for good faith actions. Strategic litigation should push courts to decide constitutional violations on the merits instead of ducking via procedural thickets. Empowered civilian oversight with subpoena power and binding discipline, stricter decertification regimes, and measurable training and early warning systems can change incentives administratively. Transparency and state tort reforms offer parallel remedies when federal routes falter. None of this escapes political resistance unions, budget limits, and conservative jurists will push back. But sustained public engagement, electoral pressure, and civic vigilance are the tempering fire that will determine whether reform is mere brass polish or wholesale remodeling. Which do we choose as our civic inheritance?